is the presidential candidate of the PDP, the presidential candidate of the Labour Party, and they had issues. They raised the issue of 25% in Abuja. The Constitution says, I hope I quote it right, that for someone to be declared president, he has to have 2/3 of how many states now? And the federal capital, and the federal capital. What does that mean? What does it not mean? Is it another state? Is it not a state? That I can understand. They talked about double citizenship. They talked about narcotics allegations. They talked about also the issue of certificate forgery. All of those were technicalities according to some lawyers. We'll get the definition of that. Then we went into the real issue about irregularities, how votes were stolen and beavers was not used, and the justices. And the funny thing, there was no dissenting judgment. All of them did say that you did not prove your case. So I've got a lawyer. I've got Jeff Wilcox in the studio, and he's going to be using his legal expertise to educate, because a lot of us were sleeping through the court proceeding yesterday. I mean, I slept like twice, I would not lie. I was watching till I got into the studio, and I slept like twice. But he's going to help us. Welcome, Jeff.
Thank you, Mr. Kalada.
All right, so let's get straight to the point. First, what is your take on the judgment? A lot of people have, reacted to it. Some have said Ojoro, like we say in our local parlance. Some have said it's the law and it has taken its course. But as a legal practitioner, where do you stand?
Yes, thank you very much, Mr. Kalada.
Yeah.
As a legal practitioner, I will not fall into the temptation of following that of public sentiment.
Okay.
So I cannot come and sit down here and say the judgment is technically wrong, because that would be me sitting on appeal on the judgment of the Court of Appeal, which sat as the Presidential Election Petition Tribunal. No, they are courts, not tribunal, because the Court of Appeal. Okay. So it sat as a court.
Okay. So I think that's the correction I would have to make. Yes. We always would call it tribunal, so it's a court.
Yes. Now. When the Court of Appeal is sitting on this matter, is a court, not a tribunal.
All right then.
Tribunal is for the local government election petition, and the governorship election,
the state
petition.
Election. Yeah.
Okay, so I think the courts, the justices of the Court of Appeal, did a good job.
You think they did a good job?
Yes, because you see, the court decides on facts and evidence before it, brought before it, put forward before it. The scenario is like the judges, which are their justices in this instance. Judges are for the High Court. The Court of Appeal.
Legal terms again.
Called justices.
Okay, I learned another one.
The justices are presumed not to be there when the matter you have brought before them were going on in the public. So it is only that which you brought forth to them in their court, laid before them, that they will decide on.
Now that you've brought up this issue about evidence brought before them, you are on social media.
Yes,
a lot of people say, oh, we brought evidence, but then the APC's lawyer argued and said this evidence should not be taken by the court, and you agreed, and so that makes you unfair. What can you educate us on that?
Yes, you see, people think the evidence that was brought before the court was wrongfully refused. But you see, in our judicial system, there are rules to this thing.
Okay.
You don't just come to court and bring anything and the court will admit. We have rules to admitting evidence.
Okay.
We have admissibility of evidence.
Okay.
And we have things that you must lay before the court can accept or reject it. Now, those are where the public don't understand.
So can the opposition, so you bring something to court and you're asking the court to admit it, can I counter you? Does the law allow me to counter you?
Yes, that is why we have the Evidence Act. We specifically have the law that regulates admissibility of evidence.
Okay.
It is provided under the Act. That's the Evidence Act of 2011. they've amended it to include some new provisions of law. Now, if your evidence before the court does not meet the requirement, the admissibility test, it cannot be admitted. You see, everybody have become lawyers because of this election, which is very good. But everybody, you can't be a lawyer until you know the tricks, the ropes, and the knowledge of the law. And that's why lawyers are there. Else, every man can go to the market and buy a wig and gown and go to court and carry your book. You can read it is ABC, black and white, but there are technicalities which you must follow the rules before this thing can be admitted in court. Now, this for an election dispute, which is an election petition, there are rules laid down so that it cannot be free for all. You must follow the rules.
All right. Now, talking about rules to admissibility of evidence, do you think that the petitioners, the PDP, the Labour Party, and its candidates, did a good job in trying to prove the case?
Yes.
I saw some of your posts online, and that's why you're in the studio.
Yes. I think that is where the issue. I will not blame them because when they have a time factor constraint.
Okay.
And whatever they did, they were trying to meet up the time allowed in law.
Okay.
And however you see it, litigation is a game, not like a contest. There has to be a winner, there has to be a loser.
Yeah.
Now the petitioners, I don't want to specifically use either P because there are 3 petitions before the court yesterday.
8 p.m.
There was
well.
8 p.m., there was PDP, and there was LP. Now they had time to bring this petition before the court, and time were allocated to how they can go about it. They tried within the time allowed, but from the judgment of the court, they failed to bring the vital evidence before
vital.
Yes.
Now, INEC has also been said to have been a constraint because I was looking at a report by LP lawyer saying INEC did not allow them certain documents. What do you have to say about that?
Yes, that's the problem. You coming to court should be ready. You already knew that if this don't go your way, you will go to court. You prepare, you do your groundwork. Now, the law allows political parties to have polling unit agents.
True.
At every polling unit.
Every polling unit.
Now, if you look at the judgment of the court specifically said it was on evidence that LP said they had 133,000 polling unit agents. I won't come here to cite Evidence Act, Electoral Act, so I don't confuse, because I believe we should be able to break this thing down to the general public who don't understand.
That's why you're here. That's why you're here.
Now, if you know how election is done in Nigeria, after the election has been concluded, the counting goes on at the polling unit. The form EC60, if I'm right, is being collated, signed. That's the one they paste at the polling unit. It's presumed that your polling unit agent is given a copy. It is on that ground that you came to allege there were irregularities. Now, your polling unit agent ought to have their copy. INEC gives you certified true copy. Now, in the event that INEC does not have certified true copy to give you, that's your polling unit copy. It's a counterpart copy. You should present it before the court and tell the court that INEC refused to release this copy. So we have 176,000. I'm trying to polling unit all over the federation.
170 something. I can't remember. Yeah.
All over the federation. Yeah. It is presumed that you had polling unit agents on all those polling units. Where is their own counterpart copy? So when you say INEC frustrated you, what about your own copy? I don't even understand.
I get you.
Of course, INEC was an adversary party in the petition. They were defendants, respondents.
Yeah.
Of course, you were alleging that they did this, they didn't do this. You don't expect the opposition to be, even when you subpoena them, they come as an unwilling witness.
Yeah, of course.
Now, that is where the error came. They came to, according to the judgment, remember, we were not at the tribunal, the court. When cameras were not allowed, we were not there. So what we are relying on is what
based on what the justices
and the court ruled according to his record. Now, the court said the petitioners did not show to this court their own copies of this document, which is to prove that they won the election, because there were allegations that there are some areas we won, they reduced our score. What was your score? In fact, the court in Justice Musrat Bolaji Yusuf stated it, that the petitioners wanted the court to go and look for evidence for them.
Was that really the case?
Like I said, Mr. Kalada, we are relying on the judgment of the court. And that is why now, if that's not the case, there is what they call record of proceedings, which will be open to the petitioners. And that's where the appeal comes in. They can argue that because now they have seen the judgment of the court and they have said, they may argue that the court said what did not happen. What is now you can prove is the record of proceeding. Now again, Mr. Kalada, the difficulty they have is that you are alleging irregularities in all these polling units. To be able to bring it before the court within the time allowed by the court for you to prove is always a difficult task. So I feel sorry for the petitioners in the sense that they have so much to do within
a limited time. So I have to pause you now. We will come back to technicalities. First, a commercial break, and then when we'll come back, my guest is fired up. You stay tuned. More to come. Stay tuned. We've got Jeff Wilcox, a lawyer, and he's in the studio, and we're looking at the presidential election petition court's judgment. I've just learned two things. When it's the Court of Appeal, it's a court, not a tribunal. And when it's the Court of Appeal, it's justices and not judge. So, I mean, I guess you're learning too. All right, so Jeff, we talked about being able to prove, but let's look at the idea of BVAS and IREV, because it looks like the focus was there, but rather you've just explained that they could have gone the manual way, and that would have been an easier way for them to prove their case that, in, let's say, my local government area, for instance, there were irregularities, and the votes that could have gone to XYZ went to ABC. So what's your take on that?
Yes, on the issue of BVAS, first of all, the only electronic device that the Electoral Act, expressly stated should be used for this election is BVAS.
Okay.
That's the one that is expressly stated. IREF was brought in by INEC guidelines. Now, BVAS was used, and by the Electoral Act, any polling unit where BVAS was not used, such just results
will be cancelled. Yeah.
But the issue of IREF, it was at the discretion of INEC.
And that's what the law says?
And that's what the law says.
Really?
Yes, that's what the law says. If you look at the Electoral Act section 47, particularly section 52 of the Electoral Act, gave collation, transmission, counting, collation, and transmission of results at the means or mode as prescribed by the commission.
But a lot of people have argued that the mean and mode was BVAS transmitting to IREV.
The Electoral Act did not say electronic transmission should be from BVAS. It says INEC can make regulation. Pursuant to that provision, INEC now made the regulations for the conduct of the election, the INEC regulation and guidelines for the conduct of election. It is in that guideline that INEC, among other things, said results will be transmitted from polling unit to the INEC server, which is IREF. That is not law, that is guideline, meaning that they can drop it at their instance where they see difficulties, which was what INEC came to argue. But had the Electoral Act, which is the parent law, the governing law for this election, stated clearly that INEC must or shall, not me, shall transmit election from the polling units to the INEC server before the election result can be taken as authentic, then INEC would have. Where you fail to do that, there is an irregularity.
But is it possible, even in other countries, is it possible to have one system of transmitting results? Is it possible to have one system?
But if you look at, I'm not here to hold brief for INEC, but I think the lawmakers, in trying to make our peculiarities, Nigerian issue into consideration, because election is not held only in Lagos, Port Harcourt, and Abuja. Election is held all over the federation, especially the presidential election. The whole Nigeria is the constituency of the president. Now, what happens in the remote village where you have network issue?
Even in Port Harcourt, you could have network issues.
So I feel that it is on that ground that they did not make it mandatory. Now, if you now look at the Electoral Act, as stated, that if you look at this section, I think it's section 134(2) of the Electoral Act, it states that anything that is in the INEC regulation that is inconsistent with the Electoral Act, the Electoral Act prevails.
Just like any law that is inconsistent with the Constitution, the Constitution prevails.
Because Electoral Act is the principal law for the election. The guideline is like rules we can adopt. That's why you did not see fine. If you fail to do this in the guideline, you pay. But in the Electoral Act, if an officer fails to do a particular time, there is a fine of either 500,000 because it's a law.
Okay.
Now, Another thing again I want us to, because I feel we can use this medium to break this down to the people that listened to the judgment that did not understand what played out.
All right.
On the issue that evidence brought before the court were wrongly dismissed, so to favor the respondents. I think we have to be very careful with that.
Okay.
Now you see, in the law court, when a party brings a piece of evidence to be admitted, because when you bring, let me just play the scenario to you. When you bring your evidence to the court, it's mere pleadings. It's not yet in the record of the court. The court has to first look at it. The other party will look at it and give the court reason why you cannot bring it into the record.
Because it has to defend itself.
Good.
Okay.
Now, in this case, the court being time bound, they don't allow, like we do in the regular court, for parties to make those arguments where the court will now adjourn and rule on the admissibility of this evidence. So what the court did is that bring everything, bring it, we'll put it in the record. In your final written address, you argue why we should or not take it, so that we can give a ruling. That was why the court started from preliminary rulings. So what the court did was that all those boxes or ballot papers or whatever you saw, everything was brought in during trial to save time.
Oh.
Because if the court kept allowing argument, 3 years will go. They will keep arguing on why this was not certified. If you remember, there was one point as to this CTC brought in by PDP should not be admitted because the amount paid as certification fee was not written or endorsed on the document.
Okay.
APC, yes,
that's technicality.
The court had to give ruling for almost 30 minutes on that point. And the court refused the argument, saying that as long as PDP showed evidence of payment, which was received, in fact, the court even berated INEC, saying that you collected an amount of 6 million plus, yet you're now refusing us to accept this document. Now, imagine if that was allowed during trial. I'm telling you, as we speak, the court will still be arguing.
Right.
So it was on that ground that they allowed these things to be admitted at that time, subject to argument as to the admissibility during trial. Now, the courts, most of those documents were brought in after parties had closed pleadings. You see, these are terms that the layman may not understand. Okay, there has to be rules as to how our dispute will be fought. You file your own case, your own issues. I respond. You look at it, you respond. There has to be time limit for which all those backward and forward must end. Now, under the Electoral Act, it is very stringent that there is no room for you to now come after. When we have agreed that pleadings has closed, matter has now been adjourned for hearing, for you to now bring an application to say, my lord, allow me bring a particular document.
You're going to elongate the
system. Now the petitioners tactfully, craftily brought in an application called subpoena, that they want to subpoena a witness. Before you bring a subpoena, it means that the witness was not willing to come on his own. Now, in the guise of trying to bring in those witnesses, they brought their own witness that they could not have front-loaded when they had time. Maybe they were not ready. And the respondent argued that no, this is not a subpoena witness. These are your witnesses. That you had their evidence. You had what they wanted to say. Why did you not bring it to us so that we will have rights
to respond? Because
in our adjudicatory procedure, you do not take the other party unawares. Whatever you want to bring before the court, the other party must see, so that the other party can have right to respond. But if there's an exception where this document is not within your control, so when you want to force somebody that has it but will not give you willingly, then you have to ask the court to force the person to bring it. Now, there was no way you could have front-loaded such document because it wasn't in your control.
Yeah.
But not the expert report of your witness. The expert opinion of your witness.
So the time frame for that had passed.
Good, that passed. So the court had to apply the law and refuse, which it would have done during trial.
Now let's get to technicalities now, because you mentioned technicalities. Was first of all, was the 25% Abuja a technicality? Was that something you were comfortable with, the definition? You know, the Constitution was quoted as to saying that the Federal Capital Territory will be seen as every other state, and the president will be the governor, and the National Assembly would be the assembly in charge of it, and all of that stuff. Do you agree with?
I think the court agreed with me on that, because I had argued that it would have been absurd for us to hold that Abuja has a special status. Because yes, the court say you must win 2/3, that's 25% of the 36 states and FCT, meaning 37.
Yeah.
Now, if you now say, that was my argument, which the court agreed. If you now say, for a man to govern Nigeria, or a person to govern Nigeria, the person must win 25% of Abuja. So it means that a person can win 36 states, get 25% in 36 states. The mere fact that he did not get 25% in Abuja, he cannot be president. I think that is taking Abuja higher
than the other
and making the
states.
bar too high. Because subsequently, if that is the position of the law, and at the Court of Appeal sitting as the presidential election petition court held that position, that would have been the law. Because that had not happened in this country, because it's like if all subsequent, the previous president has all won, gotten 23rd to third, that's 25%, but most of them did not win Abuja as to majority. Now, if the Court of Appeal, the issue was the word used was it inclusive or exclusive? You see, that is what people don't understand, that this may be pure English language, but there are rules of interpretations. Now, the court has decided, at least the Court of Appeal in this level, that word "an" means inclusive. Sorry. Means the "and" means Abuja will be counted to mean.
That's inclusive.
Yes,
inclusive. Yeah.
To mean part of the state that
Inclusive.
will make up your 2/3.
Yeah.
Now, another way you can look at it is that, let's assume you had only one state to make it 2/3 for you. I don't know, I'm trying to explain something to you. And Abuja is that one state that made it 2/3 for you.
So that means you qualify.
You qualify, but you did not win the 2/3, excluding Abuja, using the 36 states. That's what I understood it as. So I feel the
But some lawyer was on national TV this morning and said, if we say Abuja is a state, every state you have to win 25% of your state,
yes,
of the local government in your state, to be able to qualify. So if the president is the governor of Abuja, should he not be winning 25%? There's an argument like that.
Yes. You see, yes. Like I said to you, that, you see, it's an issue of law that has been stated yesterday.
Yeah.
That's where I'm trying to explain to you. You see, the law, the law is dead in the book until given life by the pronouncement of courts.
Oh.
The courts are the ones that make laws. Because we have what they call the realist school of thought in law. Now, to the realist, the law is only that which the court will say, and nothing more pretentious. That's what that's Sir Oliver Wendell Holmes. He said, to the man you brought to court that he has committed an offense, as he's sitting down there, he's not interested in what the law book has said. He's waiting to hear what the magistrate will pronounce. To him, that is his problem. So that's why, so we are looking at the realist school of thought of law now, because we have various schools of thoughts in law. Now, the court has applied the realist school of thought and have made law. And they have interpreted for the first time the status of that Abuja, making it 20. So, except the Supreme Court thinks otherwise, then that will not be the law. So, as it stands today, by the pronouncement of the Court of Appeal, Abuja is not ranked higher than any state. But in calculating the Nigerian state, is seen as a state. For administrative purposes, the president is the governor of the Abuja, which is FCT, which is administered by him through his minister. But in the coalition of Nigeria, it is also, because he gets his allocation. Monthly allocation. Abuja is giving money for his running of his affairs. So we cannot, in the calculation of the 2/3 majority, which is 25% of 36 states, including Abuja, to mean that this must
I want to ask you a question because we almost have time.
Yes,
Sorry,
okay.
I have to pause you.
Yeah, it's okay.
Technicalities now.
Yes.
Double nomination, APM brought in that, and it was seen as a pre-election matter. And then the judge went ahead to explain that even if we go beyond pre-election matter, there was the withdrawal of the senatorial nomination before he decided to go in for. And then there's also to talk about citizenship, double citizenship.
Yes.
They gave a judgment on that. What's your take? Even the certificate forgery, the narcotics allegations.
Yes, quick one.
Yeah, quickly.
On the issue of the double nomination, the law has been stated before now. In fact, the Supreme Court upheld it that the person who came to complain is not the bereaved. Let's go there. I want us to make this clear. That APC, because APC also complained against
Labour Party
Obi's candidacy.
Yeah.
Now, the law is that the people that ought to have brought this issue of double nomination should be somebody that participated in the election, in the primaries of the political
that's the
party.
Supreme Court's judgment.
That's the judgment. Of course, once the Supreme Court has given decision, the Court of Appeal only acted on it because it was an issue before the court and parties joined the issue. Now, two things happened. The court only went further, like I said, because parties had joined issue. But the court said one is the pre-election matters that would have been brought up at the High Court. Court deals on jurisdiction. No matter, the Supreme Court cannot just assume jurisdiction over a matter that is supposed to be at the magistrate court. No matter how apex they are, they will lack the power to do that. So the Court of Appeal held that it does not have the jurisdiction before it, one, to hear that double nomination. It would have been a matter that will be properly argued before the Federal High Court, which is a court that has the power to hear pre-election matter. And even at that, you can only bring a pre-election matter 14 days after, within which the action you complained of happened. The nomination of Kashim Shettima was before the election. It's over 14 days. So one, you can't even hear it. It's now what they call statute bar.
Statute bar, yeah.
Secondly, you that came to complain, it is not your problem. You are not in this political party. Now, on that ground, the court dismissed that grounds of disqualification, because had the court disqualified Kashim Shettima for having a double nomination, then it means that the candidacy of the president, Bola Ahmed Tinubu, would have been disqualified. That's one. I know we are running out of time. Secondly, the court also stated that on the issue of forfeiture, that's the narcotics,
yeah,
which was the grounds for which the petitioners relied heavily. The court held that the evidence before the court, one, showed that under section 137, of the Constitution, which is the grounds for which the president is disqualified from contesting.
I did hear that part of the judgment.
It has to be on the grounds of sentencing for crime. It has to be criminal liability. You must show that the person has been charged, tried, and found guilty of the offense. Dishonesty, felony. Now, that same section has, but the evidence before this court, which is what the court looked at, said that there were evidence from the American courts that it was a civil forfeiture,
not a criminal
forfeiture. And even the term civil forfeiture has also been used in Nigeria. The court cited the case of Jonathan and FRN, where the court declared the issue of civil forfeiture. So if what is before us is not criminal, then you cannot disqualify the man on that. The court now went further, assuming it was criminal. The issue you talked about happened 10 years preceding the election. There is a provisor to that section 1.3. I hope I'm getting it clear. They said the lawyer does not know all the law, but we know where to find the law. Yes. So, the court now said there's a proviso which is section. I
think I know where it's something about the duration of your crime, which
10
allows
years.
you. Which allows
even
you
at that, the man cannot be bad because it's over 10 years. Now, on those two grounds, if you remember, that is the only place the respondent defended the petition.
That's where they called the witness.
Yeah. They called a witness that practiced in the United States, because they felt they needed to rebut that part. And also there was also evidence that some time ago in 2006 the Nigerian government had written to the US government
through the IGP
asking for the criminal record of Mr. President, and there is letter signed from the US saying that we do not have, like I said, is a court of law and evidence, not sentiment. So it is on this ground that the court found that the president is eminently qualified, as he has no limitation for contesting.
Let's get to double citizenship. What does the Constitution say about that?
The issue of double citizenship is in PDP, is on PDP's petition. Now, a Nigerian citizen by birth cannot be disqualified
as someone who has double
citizenship. That is where this happened. You see, some people you can have citizenship by naturalization, citizenship by marriage, but the president is a Nigerian born in Nigeria. That is what the Constitution allows.
So what does the Constitution ban? The one who comes into Nigeria natural?
Yes, it cannot be a Congolese, a Togolese, and now came to acquire a Nigerian citizen and now be our president. So you have to first relinquish your Togolese citizenship.
Yeah.
The mere fact that you have been a Nigerian citizen by naturalization, you must forfeit. You can't be double citizen in this instance. So that is where the court held that the president is not barred from, because although they rebutted it saying that the president is not a citizen of Guinea, right?
Yeah, something
but
like that.
Even at that, the court said as long as he's a citizen by birth, he was born in Nigeria, his parents are Nigerian, he's qualified to be the president.
Okay. I don't have time. Goodness me! But one final question. Wow, time is fast spent.
Yes.
There's another issue. The issue of the certificate. Was it ruled on? Oh, it wasn't. I can't, because I didn't follow all of it. But where does your sentiment lie? Because someone listening to you will think you are in support. Now let's leave the facts and where does your sentiments lie?
Yes, my sentiment lie in the fact that the Electoral Act as it is makes it almost impossible for a petitioner to successfully prosecute a presidential election petition.
All right.
This is why is that if a person claiming irregular, I want to speak on the grounds
quickly,
of
yes.
Then the time